Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book from Oxford University Press. Now this book is very important because we are looking at Brexit Day in not that many months away. I'm recording this in the autumn with about 6 months to go. And of course the EU is the big issue in Britain with Brexit. This book's been written by Caroline Naome and, as I say, appeals before the Court of Justice of the European Union. It's a particularly important area because that is still a subject concerning the appeals themselves which we do not know an outcome for, because we don't know the final terms of Britain's departure from the European Union. So this book, I think, is very important for 2018. Now, Elizabeth was the lead writer on the book, and she and I talked about the book in some detail, and we've given the title for our book review the following: Dislike bringing an appeal? This new text offers a useful European perspective, and that's exactly what you're getting. It's very much the house style for OUP. There's the book itself. Front is a hardback, black cover, spine, nothing on the back. There's the spine there. Now if we go to the back of the book, you can see immediately that what we've got paragraph numbering for the index. The book runs to about 300 odd pages. It's not a big book at all, not a heavy book. It's very well researched throughout, as we expect. Very much the style of OUP. You can see the index there. And then if we go into the back of the book, you've then got a detailed bibliography. Again, these are profound works, and they add a tremendous new dimension to our work as lawyers. There are some appendices, of course, at the back looking at figures and various other things. Let me go to the front of the book now. You can see there's the front page. And as I say, after that, you've then got the detail about OUP, and you've got a foreword. The foreword is well worth reading. It comes from Alan Rosa, who's a judge of the Court of Justice, and it was written in January 2018. As I say, I'm recording this in the autumn of 2018. There's the acknowledgements there, and then the table of contents. You can see the structure of the book, and then running all the way through the various chapter headings. There you can see as I run through them. A total of 12 chapters, and I think it's 6 appendices at the back. Then you've got the bibliography and the index. Legal aid is covered. In fact, in one of the sections, that's the penultimate chapter, which is looking at the procedure before the Court of Justice. Then you've got the table of cases. There are quite a lot of cases in this area, as you can see as I flick through. Then you've got the table of legislation, and then after that you've got this is national treaties as well that are included. Then you've got the list of abbreviations, fairly short but always useful, because it's sometimes a bit difficult to remember what some of the abbreviations stand for, and I can't remember them, and I'm sure many other people can't, so it is very helpful. Thank you for that. This is the way the book is structured. There's the front, chapter 1. You can see paragraph numbering at the side there and footnotes. So you've got a lot of detail, and it says what the objective of the book is. Then it goes on to the creation of the Court of First Instance, and it runs through logically all the way through, and that's the way it is. You see some of the footnotes are very long indeed. But Caroline has produced, I think, an extremely important book. And as I say, it's a topical book. So what do we say about it? Well, this. As most lawyers are aware, presenting an appeal can be a pain. And I can say that, having just done one in the last couple of days. The appeals procedure is very different from the normal way that you do things. So you have to take other considerations into account. And it's an arduous procedure. As we say, it definitely can be, assuming that, of course, is if an appeal is even granted in the first place. So, of course, I go through quite a lot of oral hearings just to get permission to get to the appeal, by which time I've fully rehearsed everything in the first place. But, however, we're not talking about that. We're talking about this book. Now, equally daunting, of course, when you're doing an appeal, if not more so, is the challenge of launching an appeal before the Court of Justice of the European Union, the CJEU. Used to be called the European Court of Justice, but it's now the EJEU. Now, there's little doubt then that practitioners finding themselves faced with a such a task should be profoundly grateful for this new text recently published by Oxford University Press. OUP, I think, have done a really good job, and the author, Caroline Naome, has been particularly good in bringing everything together. Now, writing in the foreword, Alan Rosa, who's a judge of the Court of Justice, and that's the abbreviation basically, instead of the saying CJEU, we just call it Court of Justice to save a few words. Now, he refers to the book as an indispensable reference work for the appeals procedure. Available, of course, in both English and French, this book will shed light for the reader on the current case law in the Court of Justice and the relevant provisions of the Court's statute and rules of procedure. And he says, by adding this, that the historical development of this class of judicial remedy receives considerable comment throughout, and that's notably in the first chapter, which is really the, if you like, the historic background to where we've got to. I mean, we still don't know in the UK where we're going actually with this, but we will know, hopefully, by the 29th of March 2019, which is Brexit Day. Now, the 11 chapters which follow deal with all the pertinent aspects of an appeal, including the concept of an appeal, the decisions open to appeal, the effects of appeals, grounds of appeal, and much more. In fact, all the stuff that you get, depending on what type of appeal you might be doing within the England and Wales jurisdiction. So it's nothing particularly new, it's just slightly different, if I can put it that way. Now, the chapter covering grounds of appeal we thought was quite detailed, and usefully so, as it's the chapter on the procedure itself before the Court of Justice, which is right towards the end of the book, which has in fact 9 sections in it. This is the procedure part, including the written and oral segments of the procedure. And I have to say that we've got since I was called to the bar some decades ago now, we've got a very different way of doing our work, and I'm sure that's going to change again with information technology changes and the £1 billion reorganisation of the court structure in England and Wales alone. But we are certainly moving in a new direction about the way in which we actually conduct the procedure. And the Court of Justice of the European Union is no different. Now, beleaguered practitioners will, of course, derive much more from this logically organised text. And the author, Caroline Naome, remarks, quote, "There can be no doubt that practitioners dislike bringing an appeal before the Court of Justice of the European Union because it demands mastery of a particular technique." A very good point, that, I think. As a referendaire, I hope I've pronounced that correctly, at the Court of Justice, Caroline reminds us that the criticism must be directed at the judgment under appeal, not at arguments put forward by the opposing party. Further points of argument here are discussed in the text itself, and that's, I think, quite an interesting observation, because we're talking about the judgment itself. And remember, when you do an appeal, you are looking at I will use one judge as an example. You're talking about one judge, so I'm saying he or she has got it wrong. So I'm going specifically to what the judge has done, and I'm not looking at the other bits. And I think that's the important thing to bear in mind for appeals. Now, on even a cursory examination, the book reveals itself impressively as a carefully researched, very analytical, and thoughtfully argued, and yet it's a succinct analysis of what the author refers to as the state of play in this area today, including, amongst other things, the development of the rules governing appeals, the case law, and the rules of procedure themselves. Again, that is covered in some detail. Let me conclude by saying this, because I do think, as I say with many of the OUP books, this is a real gem and a very helpful book for all of us in this area. And this is especially valuable, I think, for researchers, judicial and academic, as well as practitioners. And of course, the bibliography is fantastic, and there's a very useful, possibly over-extensive footnoting, although I shouldn't really say that, but there is a lot of it. And its wealth of references are very helpful, plus, of course, the tables of cases, quite a lot more than one would think, and, of course, the legislation, including the treatise and so forth. And there are, of course, 7 annexes, including Annex 2, which I thought was very helpful, on steps in the handling of an appeal. The 4th annex also deals with the outcome of appeal cases, which again will help. Then you get some statistics at the back. It's erudite yet accessible, and here, we say, is a work of reference which will undoubtedly prove itself useful and certainly enlightening to any lawyer tasked with the handling of an appeals process. And the publication date is cited as 2018. Let's just have a look, one last look at the book. There it is, the front of it. There's nothing except the spine, nothing on the back. But that's the front, black cover, hardback. As I say, just opening it in the middle. 9. Consequences of a finding that the plea appeal is well founded. And that's ineffective pleas, and again you can see the structure, the paragraph numbering. You've got all this footnoting as well, so there's a lot of detail running all the way through. And of course chapter 11, which I mentioned before, which I think is very important, is the procedure before the Court of Justice. And I think that's the one that many people should go directly to if they're doing any form of study, whether it's for examinations or just general reading, because it gives you an idea of how the thing is structured. And I'm afraid procedure today is all important. It doesn't matter what you're doing, you really have got to have your finger on the pulse of procedure in order to get anywhere near having any form of success. And can I just say one last thing about appeals? Any of the jurisdictions, I've been doing a number recently, as I've indicated, but they are a special jurisdiction, and it's not the same as doing a trial itself. So you have to do a lot of homework. Always prepare. That's, I think, the biggest key. Thank you to Caroline and OUP for an excellent book. Really enjoyable and very, very helpful for all of us. Thank you. Bye-bye.